We are not finished. We are not finished. We are not finished.
The submitted firearm brace, when attached to a firearm, does not convert that weapon to be fired from the shoulder and would not alter the classification.
Not one more! Not one more! Not one more!
Distribution of 10 to 40 million of these braces and the implementation of your rule. Did Congress pass a law?
The ATF's frames and receivers rule has been declared illegal and outside the scope of the ATF's authority on a national level. But the ATF is still fighting, so let's talk about this. Vanderstock versus Garland. The Firearms Policy Coalition defeated the ATF and the fraudulent Biden regime. On June 30, 2023, the so-called frame and receiver rule of the ATF was declared invalid by Judge Reed O'Connor of the U.S. Northern District of Texas Federal Court. The Firearms Policy Coalition, on behalf of the plaintiffs Jennifer Vanderstock and Blackhawk Manufacturing Group, filed this lawsuit to challenge the legality of the ATF's frame-receiver rule, which stated that 80% of frames and receivers, jokingly referred to as ghost guns by anti-gun extremists and the left, were identical to finished frames and receivers. A frame or receiver that has been machined 80% of the way must still be machined 20% more by the customer before it can be utilized to create a finished working handgun. In April 2022, while giving a speech at the Rose Garden, Biden famously committed a crime while it was being broadcast live on television by having a Polymer 80 made 80% Glock frame and jig, an entire slide kit, in his possession. Possession of an 80% frame or receiver is a felony in the District of Columbia. Journalist Emily Miller was one of several who contacted the ATF, the U.S. Secret Service, and the White House to inquire about how this kit and frame jig were obtained, who snuck it into the White House, and who provided it to Joe Biden for his publicity stunt. To date, none of these organizations have responded to several emails or calls requesting comments. But enough of that, let's continue. The fraudulent Biden's executive orders instructing ATF to simply create new laws out of thin air that they refer to as rules to ban or restrict the items at the top of the anti-gun enterprises list. Bump stocks, 80% frames and receivers, and pistol braces was the result of pressure from the White House over Biden's failure to force gun bans through Congress. In a now-deleted piece explaining the regime's plans, the Washington Post outlined Biden's anti-gun agenda. However, the BBC's detailed coverage of the regime's plans is still online and may be read at the link below. Keep in mind the phrase "pursue federal charges against those involved in the trade of such weapons," which Joe Biden used to quote the article. After the tragic concert-slaying rampage in Las Vegas, former President Donald Trump famously backdoor banned bump stocks. He did this by administratively amending the law to add them to the National Firearms Act of 1934, which mandates government registration of all fully auto firearms. He did this by issuing an executive order instructing the ATF to reclassify them as mash guns, despite the fact that they mechanically are not anything like a mash gun. In order to illegally outlaw additional firearms and strengthen its own control over gun owners, the ATF was only too pleased to comply and redefine the definition of a mash gun. ATF and the then Attorney General Jeff Sessions were authorized by Donald Trump's executive order to implement the regulation on bump stocks, erroneously adding them to the NFA. NBC News enthusiastically reported the story. National Firearms Act relevance. According to the National Firearms Act of 1934, you must register a mash gun, silencer, short-barreled rifle, or shotgun with the ATF and pay a $200 tax to receive a government-issued stamp of approval permitting you to own or own it. Franklin Roosevelt advocated for and signed the NFA into law. Its main purpose was to keep bootlegging mobsters from having fully auto weapons like the Thompson submachine rifle, also known as the Chicago typewriter by Al Capone. The $200 tax and government registration during the 1930s were supposed to make these products prohibitively expensive and out of the reach of both common people and organized crime. That's no longer the situation due to inflation and the devaluation of the US dollar, yet many people still resist registering anything with the government. Who can really blame them given the latest disclosures of FBI and DOJ abuses? You may find out more information regarding the National Firearms Act of 1934, including what exactly is an NFA-controlled item. What relevance does that have to Vanderstock versus Garland then? the ATF simply amended significant portions of both the NFA and the Gun Control Act of 1968, the laws that define what mash guns, frames and receivers, finished firearms, gun parts, etc. are, with the bump stock ban being the first of 3 such statutes. Congress defined these items in very technical words and language, and the ATF changed those definitions in recently published rules to support gun control objectives.
And having to tell her that other 9-year-olds were just killed in a shooting is horrific.
Get on the ground now!
I'm a federal agent.
917-110-3.
I'm a federal agent.
Get on the ground!
Real background checks could stop a lot of illegal guns going in different places in the country.
Shall not be infringed, and the word infringe means by banning parts on firearms actually is against the Constitution.
The approach used to impose the bans on bump stocks under Donald Trump and Joe Biden, on 80% frames and receivers, and on pistol braces was the same. In order to further restrict or regulate these items beyond what the 2 laws really indicated, the ATF misused and exceeded the statutory regulatory authorities granted by the GCA and the NFA. Chevron deference is the legal principle that the ATF asserts gives them the authority to do this. The intention was to exceed their legal and regulatory authority in order to criminalize products that millions of Americans lawfully possess and circulate, but over which ATF had no prior regulatory authority. The plaintiffs in Vanderstock v. Garland claimed that ATF treated frames and receivers in the same way as bump stocks. In order to write a new rule adding bump stocks, now defined as a mash gun, to the NFA, the ATF had to change the definition of a mash gun in its determination of what a mash gun is. As a result, previously law-abiding owners of bump stocks are now required to register their devices as NFA-regulated items and pay a $200 tax. Anyone who violated this new rule from the ATF would face harsh fines and criminal punishments. However, as was already indicated, this rule disregarded the constraints of the legal doctrine it was written under and the moderating legal precedent, the Chevron deference and the lenity rule. The 1984 decision by U.S. Supreme Court in Chevron USA v. Natural Resources Defense Council, Inc. gave rise to the legal principle known as Chevron deference. The U.S. SCOTUS established a legal standard for when the court should give weight to an agency's response or interpretation, stating that this is the case when the agency's response was reasonable and Congress had not specifically addressed the relevant problem. Chevron deference and the rule of lenity. This is vitally important. According to Chevron deference, if the legislation is ambiguous, the court hearing a lawsuit will rule in favor of the agency since it is best equipped to interpret any ambiguities. This is the justification that the ATF and the EPA have both been using to go well beyond their statutory authority and rewrite existing laws, primarily the NFA, the GCA, the Clean Air Act of 1967, and the Clean Water Act of 1972, to suit their respective political agendas. The EPA has so far lost 2 Supreme Court cases in the last 3 terms. In West Virginia v. EPA, scouts found that the EPA exceeded its legal authority by imposing punitive restrictions on coal plants and automobile manufacturers by rewriting the Clean Air Act, and in Sackett v. EPA, SCOTUS found that the EPA had substantially overstepped its bounds by illegitimately expanding the Clean Waters Act. Both incidents were the consequence of political orders issued by the Biden regime in pursuit of their climate change goal. The Fifth and Sixth Circuits cited the rule of lenity in their reversals and vacates of the ATF's bump stock rule, which used the same methodology as the legal foundation for these agency rewrites of laws. These agency rewrites of laws do not apply the superseding principle of rule of lenity. In a later ruling after Chevron deference, the court attempted to limit the use of Chevron deference by adopting the rule of lenity. The rule of lenity, also known as the rule of strict construction and used in criminal law, states that when a statute is ambiguous or unclear, the court should interpret it in a way that is most favorable to the defendant, or to construe the statute against the state. The separation of powers is one of the 2 constitutional goals that the rule of lenity serves, as it restricts the use of statutory language in penal statutes and prevents the courts from defining the parameters of a crime and its penalty. The second motivation behind the rule of lenity is the need to protect the legislature's constitutional lawmaking prerogative and to limit the court's encroachment on a legislative function. The Federal Fifth Circuit Court of Appeals has determined that the ATF's expansion of the NFA to include bump stocks was an unconstitutional amendment to the NFA. The NFA has specific technical language that defines what a mash gun is. The ATF recently revised the definition and informed owners of bump stocks that they must file for, be approved by, and obtain a $200 tax stamp from the ATF and register them as mash guns under the NFA, or face 10 years in federal prison and a $250,000 fine under their new rule. Against ATF, the Fifth Circuit COA decided, invalidating ATF's rule on frames and receivers. Recently, a federal district judge invalidated an ATF rule on frames and receivers, marking a significant development in the Vanderstock case. The ATF has not given up on this matter and has filed for review by the Fifth Circuit Court of Appeals. The lawsuit, Garland v. Vanderstock, was decided by Judge Reed O'Connor of the Texas Federal District Court. The plaintiffs, represented by FBC, sought a motion for summary judgment against the ATF's new rule on frames and receivers, which came into effect in August of the previous year. This rule aimed to impose restrictions on 80%ers, polymer 80s, and parts kits sold by various manufacturers, such as Polymer 80, 80 Arms, Defense Distributed, and others. The rule was the federal government's attempt to regulate these items, commonly referred to as ghost guns. In the Vanderstock case, the plaintiff sued the ATF, seeking a federal court ruling that deems the new rule invalid under the Second Amendment. Additionally, the plaintiffs requested a preliminary injunction from the court to halt the implementation of the rule. In the Vanderstock case, as the process unfolded, the federal district court judge initially granted a limited preliminary injunction against the ATF's enforcement of the new rule on frames and receivers.
Affect us here, and it was such a breath of fresh air for the Second Amendment people.
It takes extraordinary courage for them to stand up here and retell the story.
Anti-gunners put in there to keep the guns out of the hands of lawful citizens in New York State.
Upon reviewing the ATF's rule, the judge found that it was facially invalid based on the plain language of the statute and concluded that Congress did not grant the ATF the authority to regulate these specific items. Initially, the limited preliminary injunction was in favor of Tactical Machining, one of the plaintiffs. However, the judge later expanded the injunction to cover other named plaintiffs, their customers, as well as additional companies like 80 Arms and Defense Distributed who intervened in the case. The ATF, after losing the initial battle, appealed the granting of the limited injunctions to the Fifth Circuit Court. Currently, there is an interlocutory appeal pending before the Fifth Circuit, which will also factor into the ongoing appeal regarding the motion for summary judgment. Meanwhile, as the case progressed through the Fifth Circuit, the plaintiffs continued to pursue their motion for summary judgment. A motion for summary judgment can potentially resolve the entire case without going to trial. In this case, both the ATF and the plaintiffs filed cross motions for summary judgment. Judge O'Connor recently rendered his decision vacating the frames and receivers rule, which effectively resulted in a nationwide invalidation of the rule. Judge O'Connor stated that the central question in this case is the constitutionality of the frames and receivers rule. FBC and the other plaintiffs requested that Judge O'Connor strike down the rule entirely, declaring it invalid. This ruling applies to products related to firearms and other equipment and materials, following the guidelines of the 1968 Gun Control Act. Vacating ATF's frames and receivers rule. In the Vanderstock case, the court determined that the government's recently enacted final rule defining frames or receivers and identifying firearms exceeds the ATF's statutory jurisdiction. Consequently, the court declares the entire rule unconstitutional under the Gun Control Act and vacates it. It is important to note that Judge O'Connor's decision does not directly address the Second Amendment's validity in relation to the final rule. While some may interpret his ruling as unconstitutional under the Second Amendment, he did not specifically address that issue since the rule was already deemed unconstitutional based on other grounds. Judge O'Connor's examination of the GCA's text led him to conclude that the new ATF rule on frames and receivers was inconsistent with it. He emphasized that Congress did not provide a specific definition for frames or receivers, and therefore, the words should be given their ordinary meaning rather than the defendant's interpretation. Anticipatedly, the ATF has filed an appeal in response to Judge O'Connor's decision, as judges are no longer granting Chevron deference to the ATF's interpretation of the NFA and JCA. Since the rule is entirely invalidated, Judge O'Connor ruled to vacate it completely in his decision. ATF's potential stay attempt. It is likely that the ATF will file a request to stay Judge O'Connor's judgment in the Vanderstock case, as they do not want the final rule to be vacated. However, Judge O'Connor's decision simply restored the status quo prior to the implementation of the new rule in August. The ruling did not bring significant changes, but rather reverted to what the ATF had deemed lawful previously. Consequently, it may be challenging for the ATF to argue for a stay on Judge O'Connor's judgment, considering it only restored the previous status quo. Currently, the ATF has already appealed the prior injunctions granted by Judge O'Connor, and this appeal is still pending before the Fifth Circuit Court.
To run enhanced background checks on young people under 21 trying to buy a firearm.
This government can protect its own people, except for 36 out of every 100,000 for murders.
Types of disputes that would be settled by people yelling at each other, maybe engaging in a fist fight, are being settled with guns.
I'm just inspired by the next generation. I think it's a time for a big change.
Since you rewrote the rules of asylum based on the perceived degree of violence in these countries,
the pending preliminary injunctions are likely to have an impact on the appeals of the injunctions previously granted, and it is probable that the appeal regarding the summary judgment will also be consolidated with the ongoing interlocutory appeals. Presently, the ATF's final rule has been completely overturned, and they have appealed this decision to the Fifth Circuit. They are seeking the Fifth Circuit's affirmation of their appeal. Given the Fifth Circuit's favorable disposition, it is anticipated that the Vanderstock case will experience a significant win in this circuit. The next crucial question lies in the Supreme Court stance, as they have not yet ruled on any cases involving bump stocks. Preliminary injunction in Vanderstock case. Judge Reed O'Connor of the U.S. District Court for the Northern District of Texas gave victories to nearly all of Mountain State's clients in the ongoing lawsuit, Vanderstock v. Garland, which is the center to keep and bear arms case for MSLF. The court issued a preliminary injunction against the ATF, executing the final rule against our client, Tactical Machining, in early September, after determining that it was likely the court would find the ATF's final rule, which fundamentally redefined weapons, unlawful. Producer and merchant Tactical Machining offers 80% lowers and other products that allow law-abiding Americans to make their own weapons. For Darren Peters, who started his little firm to assist people improve themselves, the court's ruling was a huge relief. Customers of Tactical Machining, though, continue to be dubious. After all, it serves no purpose to shield a producer or merchant from an illegal legislation if the people who buy its products aren't also protected. Although the ATF may not be permitted to pursue businesses, what about the customers? According to Judge O'Connor, Tactical Machining's injuries cannot be remedied if its only source of revenue, the willingness of customers to transact business, has been severely curtailed. Customers must be covered by the preliminary injunction. Customers of Tactical Machining are now secure, but this isn't the day's lone triumph. The newly enlarged injunction also covered two individual clients of Mountain States, Jennifer Vanderstock and Mike Andren. We contended that the ATF's final rule was so ambiguous that anyone who bought particular parts might be susceptible to legal repercussions and suffer permanent injury. For Americans who desire to use their basic right to self-defense, which is guaranteed by the Constitution, a threat like this from the federal government is nothing short of terrifying, Justice O'Connor concurred. In a recent ruling by the court, it was stated that the claim that a plaintiff may prevent injury by adhering to an unlawful agency rule is insufficient when there is a considerable possibility of irreparable loss. The existence of irreparable injury is shown by the fact that the plaintiff elected not to engage in the regulated activity as evidenced by their decision to desist. Your Honor, we totally concur. This win for Tactical Machining and its clients, Jennifer and Mike, is one that Mountain States and its Center to Keep and Bear Arms are pleased to have achieved. But our work isn't yet done. The illegal ATF final rule still applies to millions of Americans. We won't stop until we have ensured protections for every law-abiding American who wants to protect their loved ones and themselves. We will be there for you at every stage of the ongoing battle. Federal court curtails ATF rulemaking. When a federal judge rejected parts of the Bureau of Alcohol, Tobacco, and Firearms new regulations last month, President Biden's effort to tighten gun laws suffered a setback. The The ATF intended to legally designate unfinished weapon parts as firearms in order to forbid their unrestrained sale. The rule, according to pro-gun organizations, is problematic since the ATF is a law enforcement agency rather than a legislative body with the power to enact new laws like Congress. A temporary injunction was placed on the ATF's interpretation of what constituted a weapon policy and the steps the federal agency started pursuing against the company in Vanderstock versus Garland, a lawsuit brought by Texas-based firearm parts manufacturer Tactical Machining. That injunction was extended 7 days ago to prevent the ATF from limiting the national sales of unfinished weapon components by any company. Judge Reed O'Connor of the Federal District Court stated in his order that the court finds that individual plaintiffs and Tactical Machining LLC have demonstrated that each is subject to a substantial threat of irreparable harm. Attorney Cody Wisniewski of the Firearm Policy Coalition praised the initiative. The court has ruled that not only is the ATF's attempt to redefine the terms firearm and frame or receiver probably illegal, but that also our clients should be protected from its application. Because of this, Tactical Machining and its clients are now shielded from the application of the rule's revised definition of firearm.
Selling more guns in the last 3 weeks than we did in the last 8 months.
But for me, and for most of you, here's what it really is. It's an important first step.
When somebody bump fires, think of this as a bump fire stock and able to move.
To be clear, this wasn't based on violence. This is based on threats specifically to individuals, on gangs.
The central issue in the case, which might serve as a precedent for how much power the ATF actually possesses, is a single item called an 80% lower. These 80% lowers, which are officially referred to as rifle receiver blanks or handgun frame blanks, are not guns. They don't just lack any moving parts, they also couldn't support the operation of such parts. This is due to the fact that they aren't entirely constructed, thus the 80% designation. Whether they are precisely 80% is up for debate. Normally, federal agencies are responsible for interpreting and upholding the standards established by legislative acts of Congress. However, the ATF had started to push the boundaries of its authority to interpret the established firearm laws and definitions of Congress in recent years, despite the absence of any new congressional acts pertaining to firearms. The agency now looks to have crossed the line between merely interpreting the law and actively attempting to redefine it. The judge in Vanderstock versus Garland appears to concur with this idea. The ATF was given until October 24, 2022 to compile and produce the complete administrative record, i.e., to give the court access to any policies and procedures it attempted to utilize to redefine weapons. In order to proceed with any additional enforcement actions against these non-firearm parts, the ATF will need to rely on congressional action and properly ratified new definitions of firearm parts if Tactical Machining is successful in its lawsuit against the agency. Preliminary injunction against ATF's ghost frame receiver rule. In the Vanderstock and Garland cases at the Northern District Court of Texas, a preliminary injunction has been issued against the ATF's ghost frame receiver rule. This rule, released by the ATF in August 2022, classified certain 80% receivers as firearms under specific circumstances, potentially leading to felony charges. With the preliminary injunction in place, the rule does not take effect. Here are a few reasons why this injunction is crucial. 1. Likelihood of success on the merits. The ATF has a significant chance of losing the case. 2. Threat of irreparable harm. The plaintiffs who brought the lawsuit face potential harm if the rule is implemented without the injunction. 3. Balance of hardships. The hardships faced by the plaintiffs outweigh any potential harm to the ATF. 4. Public interest. The issuance of the preliminary injunction is not against the public interest. The four-way test is essential in determining whether to grant a preliminary injunction, and it appears that the court found these criteria favoring the plaintiffs. It is worth noting that an interview with one of the lead attorneys involved in the case provides additional insights, emphasizing the significance of the preliminary injunction. Potential appeals in Vanderstock and Garland cases. The preliminary injunction, although not definitive, often serves as an important indicator in a case. Winning or losing the preliminary injunction does not guarantee victory or defeat in the overall case. However, it generally provides a good indication of the case's direction. Now, let's consider a few key points to conclude this discussion. First, it is likely that the ATF will seek to challenge the preliminary injunction in the Fifth Circuit Court of Appeals, with the possibility of further appeals to the Supreme Court of the U.S. The outcome of these appeals will be crucial, as they will establish an interpretation of the law, which will then be applied back down to the district court level, ultimately shaping the course of the lawsuit. Secondly, the case of Cargo versus Garland, which arose from the Fifth Circuit Court of Appeals, is significant in this context. It struck down the ATF's bump stock ban, deeming it a broad overreach and unconstitutional. This case carries importance as it provides a solid precedent and demonstrates the potential impact of rulings made at the circuit court level. The ATF's frame receiver rule and the pistol brace rule are intertwined, potentially gaining jurisprudence and legal weight before reaching the U.S. Supreme Court. These cases are funneled through the same court that addressed the bump stock ban, further emphasizing their significance. It is essential to follow the progress of these cases for a comprehensive understanding of their impact and how they will unfold in the legal landscape. That's all for this video, folks. Thank you for watching, and we will see you next time.